Hi everyone, Lee Pacchia here, and I'm joined now by Appel. He's a professor of law at New York Law School. He's actually the director of the International Tax Program there. It's a really good thing that he's an expert in tax law because I really want to talk to him about some interesting comments that were made last week by the head of the IRS. Alan, thanks for joining us. Welcome to the program.
Thank you, Lee.
So in a recent speech, John Koskinen said the IRS is reconsidering the balance between enforcement and compliance with respect to the Amnesty program under which U.S. citizens can, and some would say should, declare that they have a foreign bank account.
Right.
What to make of it?
Okay. It's hard to tell you what to actually make of it until we see the policy in writing.
Right.
And then we have a chance to study it.
It sounds, looking at the tea leaves here, that there might be a departure of sorts coming.
Well, the commissioner's heart is in the right place. And what he's trying to do basically is to take those U.S. citizens who have lived abroad their entire lives. In some cases, they were just accidental citizens. They happened to be born in the United States and then immediately left the country, from having to pay steep penalties for the failure to file U.S. tax returns.
Right. The U.S. citizens living abroad are supposed to pay taxes on income that earned abroad.
The United States taxes its citizens and its residents on their worldwide income. And the citizens and residents are required to file tax returns each year and report all of their income. And to the extent that there are foreign taxes paid, the United States grants a credit for the taxes paid to the foreign jurisdiction. So in some cases, you have U.S. citizens who are living abroad, who have been compliant, who have filed the returns and paid the taxes in their home countries and would not owe U.S. taxes due to the foreign tax credit. Yet, if these people did not file the foreign bank account report, which we call the F-bar, or they didn't file a U.S. tax return, they're not in compliance with the U.S. tax law.
It was really interesting. I mean, he said that there's going to be news on ways in which they're going to fine-tune the program that they're going to put out in coming weeks.
Well,
is that specifically what they're going to speak to, you think?
Let's go over the program. I think let's go over what the program does, and then we can go into how it came about. But first of all, there's a voluntary disclosure program currently in effect. It's the third program the government has had. The first one was in 2009, and it ran for 6 months. There was another one in 2011, and that ran for 6 months. And the 2012 program has no ending. It could be terminated at any time. But what the program requires is that for a U.S. citizen who has not reported his foreign bank account or her foreign bank account, come in and file amended returns for the last 8 years, pay the tax, the interest on the unpaid taxes, plus an accuracy penalty of 20% of the unpaid taxes. Sometimes that's very little because there may be no unpaid taxes. On the other hand, there's also the foreign bank account reporting offshore penalty. Under the law, the way the statute is set forth now in Title 31 of the U.S. Code, the penalty for the failure to file the foreign bank account report can be as much as the greater of $100,000 a year or 50% of the balance in the account per year. It's a very steep penalty.
Yeah, that's a lot of money.
So the IRS has this voluntary disclosure program which would look back at the highest balance that was present in the account over the last 8 years, and there'd be a one-time penalty of 27.5% of the highest balance over the last 8 years. Sometimes that can be a lot of money if there was stocks and securities and they've gone down in value. In fact, when the program first was enacted in 2009, there was a 6-year look back, and there was a 20% penalty. And that was the year that we had the economic recession, and values have plummeted, and yet people were asked to pay the penalty on the highest value, which was a lot more.
So we have this amnesty program. It's out there. You said it was open-ended as to when it's going to last until.
Yeah.
Do you think that there is sufficient political willpower in Washington, D.C. to continue this program indefinitely? What are the politics driving the decisions that are getting made here?
I have to tell you, it's my personal view, and that I don't think it is going to be continued indefinitely, and I'll tell you why. The purpose of the program was to bring U.S. taxpayers who didn't disclose their foreign accounts into compliance and not subject them to the more onerous FBAR penalty and the potential criminal penalty. It's also a crime punishable by up to 5 years in prison for the failure to file the FBAR. But we have another law that's going into effect on July 1st. It's the Foreign Account Tax Compliance Act,
FATCA,
which is called FATCA. Everybody calls it FATCA, as it's the acronym. And what that law is doing is it's making, in effect, all of the foreign financial institutions around the world disclose the names of the U.S. taxpayers, their account balances, their identifying information on an annual basis. And if these banks do not agree, or financial institutions, and it's beyond banks, it can be funds, and there's a very broad definition of what a financial institution is, insurance companies. If these foreign financial institutions do not disclose this information, they have to enter into an agreement with the IRS to do this. If they don't enter into this agreement to become what was called a participating FFI, foreign financial institution, then there's a 30% withholding tax on payments by U.S. payors to these foreign institutions.
This is a world-changing piece of legislation.
Yes,
I got to ask here, did the United States government effectively kill offshore tax havens as a business concept?
Well, you have to distinguish.
Thing of the past?
No, it's not a thing of the past. You have to distinguish between an offshore tax haven and going after tax cheats. U.S. citizens that are living in the United States and send money offshore to a foreign bank account and do not report the existence of the account or the income on that are cheating the government. They're tax cheats. There's nothing illegal about having a foreign bank account. It's completely legal. The United States allows it. You just have to report it. You have to file the foreign bank account report. You have to check the box on the Form 1040 stating that you have a foreign bank account. And you also have to form another specified foreign financial asset form. But if you report it, you can have it to your heart's delight. What's going on now is the government, and Kathy Connealy, the former Assistant Attorney General of the United States, did a fabulous job for the government. I mean, she was terrific. She negotiated a deal with the Swiss banks where the Swiss banks basically would not be prosecuted provided they turned in their U.S. depositors, or else they would be criminally prosecuted. And they'll be penalized based on the number of accounts that are outstanding that the people didn't come forward in. So the Swiss banks are now sending letters out to thousands and thousands of U.S. taxpayers. And they get this letter and they're asked, did you participate in the voluntary disclosure program or did you not? If you didn't, then they're going to say, if you don't immediately, we're turning your name in. So the law firms are very busy with people coming through the door and wanting to enter this program.
I bet this is a huge issue that affects a lot of people all around the world, as well as the global financial system.
43,000 taxpayers came in under the program, and over $6 billion has been collected so far.
So by that measure, it's been
very successful, wildly successful. So when you ask, is it going to continue? I'm not sure. At first, the Justice Department was saying, you better come in right away because we're going to terminate the program.
Right.
You have FATCA, which the government's going to get the information anyway. Once they have it, you can't make a voluntary disclosure anymore. It has to be, you have to get to the government before they get to you. So it's hard to say. Some practitioners think this program will go on forever because it is very, very successful. Others feel that there may not be a need for it once FATCA is in full bloom. FATCA is not going to go into really full bloom until January 1, 2016. The IRS just issued guidance that is slowing it up a bit if you're in compliance and you're filing. Banks or foreign financial institutions are trying to be compliant and they're getting the W-8 forms, the information forms and W-9 forms, and they're doing what they should be doing, and they're registering. Everybody's got to be registered and get a number, a global, it's called a GIN, a Global International Identification Number, and has to put these numbers on the forms. So if they're in compliance, then the factor effect won't go into effect until January 1, 2016.
Alan, wild stuff. Thank you for coming by and unpacking this really complicated issue for us.
Okay.
That's Alan Appel from New York Law School. If you'd like to see more things that the law school is working on, be sure to go check out their YouTube channel, and you can always follow them on Twitter. I'm Lee Pacchia. Thanks for watching.